So today we are going to discuss regarding the career opportunities, which is related to the trademark law, right? So we are going to understand the difference between trademark attorney and trademark agent, how to become trademark attorney and how to become trademark agent. Okay, we have both the options. And then we are going to understand the difference between them. And then we are going to proceed with the trademark registration process in India. From the filing till registration, what happened, what is the procedure in between? We are going to understand those aspects. Okay. So starting with what is trademark attorney is, see, to become trademark attorney, you need your LLB degree, and once you are enrolled with Bar Council of any state, okay, then what you need to do is you need to apply for trademark attorney code. And why it's needed? Because if you do not have the trademark attorney code, you won't be able to file anything over the IP India site. So to avail all the facilities and to work in the trademark department and to do the filings, to do the reply to objections, to file responses, counter statement, notice of opposition, everything related to trademark prosecution process, you need to have the trademark attorney code. Okay. And from where you will procure it now? You are simply going to go to the IP India site. There you have to apply for it. Once you apply for it, you just need few details, your name, address, and your enrollment number. Basically, that's the main thing. You have to upload your bar council enrollment number registration certificate, and then within 2 months of applying, you will get your trademark attorney code, and over email it will be sent to you, okay, by the trademark registry itself. And once you get that, you can start your trademark filings. Okay, if you have clients, if you get clients, if someone says please file my trademark application, you are good to go. You can do anything. Okay, so this is the way. When you have done your law degree, right, then you do not need to do anything. You do not need to pass any exam. You just need to get your enrollment, and you just need to apply for the trademark attorney code. Okay. Now the second thing regarding the trademark agent. Okay. So now how to become trademark agent? For example, the trademark agent, you, if you do not have degree, LLB degree, okay, and you do not have any plans to do that, but you want to enter into the trademark, okay, then in that regard, trademark agent comes into play. Okay, so what you need to do is simply you need to clear the trademark agent examination. You just need to have any kind of degree, bachelor's degree in anything, and then you can apply for the trademark agent examination. It happens every year. Okay, once a year it happens. It happens every year, and you can simply go for these exams. But to prepare for this exam, you just need to have certain basics regarding that. Okay, what is IPR, trademark, how it, what is the process from filing to registration. So all these kind of questions are asked in the examination of trademark agent. Okay, so once you qualify that, IP India uploads your result, and you will become the agent then. Okay, they upload all the selected candidates result, and you are eligible to do filings and everything now. Okay, now what's the difference between trademark attorney and trademark agent? Okay, so legal qualification honi chahiye trademark attorney mein, right? It's the basic thing. Must have a law degree and be admitted to the bar. Trademark agent may, it typically does not need a law degree or bar admission. You can simply go for the trademark agent examination, and once you qualify that, you will be selected as trademark agent, and then you will have that code which is provided by the trademark registry. Now the scope of practice is that trademark attorney can do anything. Okay, from the filing, prosecution also, litigation also, everything, right? Because we are trademark attorney, and we have the enrollment and everything. But trademark agent can only represent client before the trademark office, which means that you will be only be able to perform the task which is in between from filing till registration, whatever the thing is. Okay, only those thing you can do. You cannot participate in the litigation matters, okay, which is before the Delhi High Court or Supreme Court also, in regard to the trademark infringement, trademark passing off, or rectification suit, everything. Okay, now, the trademark attorney provides the legal advice and representation, right? Whole advice, everything, how we are going to proceed in the matter, how we should, what should we strategize? Okay, so everything, right? But the trademark agent focuses only on the administrative aspect of trademark filing. They can only do the trademark filings, response to objections, simply from the filing till registration, whatever the matter comes in before the registry, only they can perform that, not more than that. They cannot be involved in the litigation, or they cannot give you legal advices regarding strategizing your registration process. Okay. So simple difference is that trademark attorney are more qualified because they hold a law degree, right? But trademark agent can also participate in everything related to the prosecution process, but they cannot do more than that. They cannot be indulged in the legal matters. Clear? I hope it's clear to everyone. Now we are simply going to understand the trademark registration process in India. Okay, I hope it's clear how to become trademark attorney and what is the scope of practice for both of them, trademark attorney and agents. Okay, so we are simply going to get into the trademark registration process. Okay, so now see, when we talk about the trademark registration process, first, if for example, if I have a client and he comes to me and says that, ma'am, I want to register my mark, any mark, logo or word mark or anything. Okay, so if he simply comes to me and says, what should I recommend to him? Okay, what should I recommend first? What should be the first step? So see, I don't know whether his mark is unique or not. I cannot tell you by looking at the mark, right? Because there are several marks which exist in the market, and maybe many of the proprietor has already filed their application for registration before the trademark registry, right? So how can I be so sure without doing trademark search? So I always, law firms, every law practitioner, every trademark practitioner should always recommend their clients to go for trademark search first, so that we can know that there can be potential objections that can be raised if there is any existing mark in the trademark database, right? So what should we do for the trademark searches? Where we perform it? So simply we have to go on the IP India site. You can just search for public search there. Once you search that, you'll simply find the public search option, and you can search for the mark whichever the client is saying that he or she wants to register. Okay, so what is the benefit of trademark search? That you know that their mark is unique or not. You come to know after searching that. Okay, and if there is any potential objection that might be raised, you'll be prepared for that, right? And you can tell that to the client. Okay, so the trademark search is an optional thing. Okay, but it's very important, I guess. When you practice the trademark law, I think it's very important. Okay, so we always suggest to our client that please go through the trademark search. Uh, for trademark search, you can charge professional fees. There is no official fee which is charged by the government to search. You can simply search for the, you can simply charge for the professional fees. Okay. And one more thing regarding trademark search, there is one new initiative by the CGPDTM, okay, which is, you know, the controller of patent and trademarks, basically registry, okay, trademark registry. So what they have done is they have initiated this thing of there is something which has been started related to the AI search, okay, and now the search became much easier and very interesting also. So I don't know whether it they have started its operation or not, but I think they have started maybe from Jan only. You have to check that, but you can do that search also. Okay, you can go through that also. Now, once you are done with the search and you think that the mark is unique enough to go proceed, that you can proceed with the application, and you can also report it to the client that yes, your mark is unique basis the search report, and then you can proceed to the filing of the application after receiving instructions from the client. Okay, now for filing of the application, what are the things that we require? The most important question, right? What are the things that we require? First, we need the proper basic details of the applicant, which is the client, right? We need to know in which business they are. We need to know what is their mark. We need to know that you know, the name, address and everything regarding the applicant, right? So now I'm going to tell you what are the documents that are required. So these are the basic information which is required, but more than that, what are the documents that is required? So in documents, to file the trademark application, you require power of attorney, which is the basic thing which we require in every litigation also, or anything, whatever we do related to the legal thing, we need power of attorney. I hope you all know that what is power of attorney. It's basically, power of attorney is kind of an authorization which is given by the client to us so that we can, file the application on their behalf and do certain things on their behalf, right? So power of attorney is for that purpose. So we need power of attorney. Now, one more thing is required. You need to ask your client whether the application should be filed with user claim or without user claim. So there is two options while filing the trademark application. One is proposed to be use basis, second is user claim. So if the client is already using the mark, then you can apply on the user claim basis. And what is the benefit of applying on user claim basis is, it gives you certain kind of advantage, okay? Because trademark registry will consider that this person is using the mark from a very long time. Then why should we stuck his application, or why should we take much time to proceed it to registration? Okay, so this is the thing which comes in the mind of the trademark registry also, and they consider this thing. So we always recommend to the client that if they are using the mark, they should always claim the application on the user base. Okay, and what is the proposed to be used? So for example, if the applicant or the client is not using the mark right now, but wants to use it in future, or from next year, or from 2 years from now, okay, so we are going to simply file on the proposed to be used basis. Now when you file the application with the user claim, you need an user affidavit, which is affidavit of use. Okay, so you need to provide an affidavit stating that you are using the mark, and since this and this date, and all information which is given by the applicant is true. Okay, and the user affidavit should be notarized on non-digital stamp paper of ₹100, and with that you can simply file the trademark application. So what are the two documents which is required? First is power of attorney, and if you want to file the application on user base, then only you require the user affidavit. But if you are filing the application on proposed to be used base, which means currently you are not using the mark, but in future you have intention to use, then you can simply move forward without filing the user affidavit. Only in the case of user claim, you need the user affidavit. Okay, so simply what we need: power of attorney, user affidavit, if you are claiming the application on the basis of user. Okay. Now, these are the four things which you require. One more thing is required: specification of goods and services. You need to ask your client under what goods they sell or what services they provide. You need to know that, right? And what trademark registry has done, they have classified the goods and services under the niche classification. 1 to 45 classes are there, in which 1 to 34 are goods and 35 to 45 are for services, and legal services also falls under the class 45 basically. Okay, so 1 to 45 classes are there. You have to ask your client in which goods and services you deal, and when they'll tell you, you have to figure out in which class of trademark of this niche classification your client's goods and services fall. And then you have to tell your client that, see, we are going to file the application under this particular class because your business relates to this class. Okay, so these are the information that you are going to provide to the client. Client doesn't know this. So as a trademark attorney or trademark agent, you should know all these things. Okay, so I hope this is clear till here. And one more thing is required, which is if the applicant is filing the logo mark, then you require the high quality image of the trademark logo. Okay, that's the thing that is required. You always should, ensure this thing that the logo mark should be very clear. Okay, so that there will not be ambiguity in the future, confusion related to the mark. Okay, so these are the basic things that we require for filing the trademark application. Okay, so now What we have done? We have done the trademark search, we have done the filing of the application. Now what's next? So once you file the trademark application, now the trademark registry will examine your application, will consider your application. Okay, once they consider your application, there are two sections of Trademark Act 1999 which can be applied to this case. So if trademark registry can raise objections under two sections, which are the technical objections basically. Okay, and there are other procedural objections also that can be raised. For example, you haven't filed this properly or anything. So those are very easy to solve objections, right? You can simply file the thing as the trademark registry is saying, right? But what happens when under section 9 and section 11, the registry is raising the objections? So it's very simple to know that now the examination report has been issued. Okay, so if the objection is under section 9, that means the trademark registry is simply trying to say that your mark is not unique enough, it's not distinctive enough, it's non-distinctive, and it is not capable of distinguishing its goods and services from others. So that simply means that you have adopted a very generic name, or you have adopted a mark that is not so unique. So that's why they are raising this objection. Okay, so how you will respond to this? You are simply going to take the two grounds. First is inherent distinctiveness. On this ground, you can argue that my mark has certain inherent distinctiveness because the applicant has created the mark on their own and they have applied their creativity in the mark. Now what you can do simply is you can explain your mark, why you have adopted it, what's the history behind it, or what's the reason behind it. Or you can also, if your mark is a logo mark, you can simply explain the mark. Okay, you can simply say that I have adopted this kind of font size which shows my creativity, which shows that I have adopted it, I have added my notion. Okay, so in this way you can reply under the ground of the inherent distinctiveness. Now there is one more ground which you can take. You can take the acquired distinctiveness, but it is only applicable in the case when you're using the mark. Okay, so you can simply say that my mark has not only inherent distinctive, but it has also acquired distinctiveness because of its promotion on website. My mark is visible on my website, my mark is visible on my bills, invoices since 10 years or 12 years or 5 years, 4 years, anything. Okay, whenever you have started using it, and you can simply say that the mark is available on all the advertisement sites, or I have spent this much of money on the advertisement and anything. Okay, whatever documents you have, as much as document you have related to using of the mark, okay, you can provide that. Okay, then what happens? Once trademark registry sees your response to examination report, whatever you have responded, and when they sees that, they will consider that. And if the examiner is not satisfied, what he is going to do is they are going to simply appoint an hearing in that matter, and max 3 hearings are, can be scheduled in this matter. Max 3 hearings are allowed. Okay, so even after the three hearings, if the examiner is not satisfied with your response, they can simply refuse the mark, or they can simply ask you to withdraw the application. Okay, these are the things. Okay, and what happens when the section 11 objection is raised by the trademark registry? Okay, so under section 11, it simply states that your mark is similar or identical to the existing mark which is found in the register of the trademark database. Okay, so that means they will provide you with certain marks which they think is identical or similar to your mark. Okay, now you have to respond why your mark is different from that particular mark which has been given by them in the examination report. So there are three major grounds, which is basically standard and general grounds, which you can use, but you have to check whether it applies to your case or not. Okay, you have to check, you have to rule out. So first ground of argument is, you can simply say that applicant is the prior user. Okay, whenever you say that applicant is the prior user, it simply means that your client is using the mark even before the usage of the cited entity's mark. Okay, whatever the trademark registry has cited in their search report, whatever the mark they have cited, but you are saying that you are using the mark since 10 years and that person is using the mark since maybe 5 years. They have just written in their application that they are using it from 5 years. Okay, so this is the ground which can be applied to your case. You have to check the history of both. Okay, the second ground of argument can be disparity in goods and services. Maybe you guys are dealing in the same class but in a very niche area, right? It can be possible that you guys are dealing in same class also but with different products, right? So you can simply take that argument. If that applies to your case, you have to check what the cited entities goods are or services are, and you have to check that what you have applied for, which goods you have applied for, which services you have applied for. So if there is any kind of difference in the goods and services, you can simply give this argument. Okay, now the third argument, which applies to most of the cases because it's kind of the weakest arguments also. So you can simply say that there is a difference between the mark. Although registry thinks they are identical or similar, you can just bring out the differences in both the marks. You can just compare the mark. You can simply say that when comparing the two marks, you should always view the mark as a whole. Okay, and you can give this argument under the heading of judicial principle of entirety, which means that whenever the two marks are compared, they should be compared as a whole. Okay, I hope it's clear. And then what happens after you submit the response to examination report? I have told you that if the examiner is not satisfied, they are just going to appoint an hearing. Max 3 hearings are allowed. Okay. Now suppose your application, now your response has been the registry satisfied with your response. They have accepted your application. Now the registry, after accepting, they will issue an acceptance order to you, which can be sent to you via the email also, and you can also access it to the status page of the examination of the trademark registry. Okay, so once you are done with that, once you receive the acceptance order, now the registry will notify you again when when the registry will advertise that mark in the journal. Okay, so what happens once your mark is accepted? It will be advertised in the trademark journal. Now what is the trademark journal? Basically it's a publicly accessible document, and once the registry accepts the mark, they wants to show it to the public, basically, that we are accepting this mark. But if any third party has any problem with this mark being registered, then what you can do is you can simply oppose this particular mark. Okay, so if anyone thinks that their mark is similar to the applied mark or identical to the applied mark, so they can stop the registration process by opposing the mark. Okay, any third party can oppose the mark. Okay, and now this advertisement period, basically this opposition window is open for the 4 months. Okay, and within this 4 months anyone can oppose the particular application if they have any problem. Okay, so I hope till here everything is clear. So now what's the next step? So for example, if I have opposed someone's application which is being advertised recently, and I have opposed, my client has instructed me to oppose that mark. Okay, and they have instructed me to do so because they think that their mark and the advertised mark is kind of identical to each other or similar to each other, which is going to cause confusion among the public at large. Okay, so simply what we need to do is how we oppose it, basically. So if my client asks me to oppose this particular mark, what I'll do, I'll simply file the notice of opposition. I'll draft it and I'll file it against the advertised mark. Okay, now within 2 months of the service of the notice of opposition, and the notice of opposition is served by the trademark registry to the applicant. Okay, to the advertised marks applicant, basically. Okay, the trademark registry is going to serve the notice. Why they are going to serve the notice? Because they charge for it. When you file the notice of opposition, it costs around 2,700 is taken by the government. And on top of that, you charge your professional fee. Okay. So the trademark registry will serve the notice of opposition upon the applicant. And within the service, once the a notice of opposition is served by the opponent, by the trademark registry to the applicant, basically within 2 months the applicant needs to submit the counter statement, which is the reply to the notice of opposition. And what is the term that we call? It's the counter statement that we use. Okay, so the applicant is now going to draft the counter statement, and they are going to file the counter statement within the 2 months of the service of the notice of opposition upon the applicant. Okay, so these timelines are very strict. Okay, it cannot be extended. These are very strict. Within 2 months you have to do that. Okay, and you should not miss these deadlines, basically. Now once the registry again, because registry again charges 2,700 from the applicant to file the counter statement. So the registry is going to serve the counter statement to the opponent this time. When they serve it, within 2 months, again within 2 months, the opponent needs to file the evidence in support of their opposition. Okay, so in notice of opposition, the opponent does not give any kind of document supporting their claims. And also in the counter statement, applicant do not write any, do not give any kind of evidence supporting their application. But now the stage which comes after the counter statement is the stage of providing evidences. So now for the first time, opponents provide the evidence under Rule 45 of the Trademark Act. Okay? Under Rule 45, they need to give the evidences, okay, which supports their opposition. And within 2 months now, the applicant is going to give their evidence also under Rule 46. And then comes Rule 47. Between 46 and 47, there is 1 month gap. Okay? Only 1 month is given to the applicant, to the opponent again, to provide any other further evidences if they have any. If they have any kind of evidences they want to provide further. Now what happens after the completion of Rule 45? Opposition hearing is scheduled by the trademark registry, where both the parties present and they argue, and the registrar is there. And then, if the applicant wins the case, then their application will proceed to registration. And if the applicant loses the case, that means their application will be refused, or the trademark registry will ask them to withdraw, or if they do not take any action, then it can be abandoned also. Okay, so simply application will not move forward if the opponent wins the case. Okay, so this is all about the procedure. And if your application is not opposed by anybody, what happens? It will simply proceed to the registration after the advertisement. Okay, now I hope you all know that trademark registration is valid for 10 years only. Okay, so every 10 years you have to renew the trademark application, trademark registration. Okay, and it is mandatory to do that. Otherwise, if you do not renew it, what trademark registry is going to do? They are simply going to abandon the application after 10 years or 11 year, 12 years. If it happens that 11 years has passed and you haven't filed any renewal, okay, then registry will abandon the mark simply. So I hope everything is clear to you guys till here. So is there any doubt regarding, do you have any questions regarding this? Anyone, any question?
Ma'am, is it okay if I ask a question now?
Yes, I think we are done with the registration process also, and we have understood the difference between trademark attorney and trademark agent. So yes, you can ask. Now this is the
Uh,
we'll take question. Yes.
okay, ma'am. Thank you so much, ma'am. It was really helpful. While you were telling us the entire process of opposition, I have this one
Mm-hmm.
doubt. So I have just recently started practicing in IPR, and I'm coming across this situation wherein the service date is not matching the filing date. So, in such a
Okay.
case, for counter statement and notice of opposition. So, for
Mm-hmm.
example, if the opponent has filed the notice of opposition on XYZ date,
Mm-hmm.
the date on which the registry is serving it may be different from the filing date, right? So,
Yes,
from
yes. But
where,
from the date of service, you will conclude that. From the
so
date of
from the
service,
date,
yes.
okay, only from the date of service, and it also is happening is even after the date of service, the receiving date from the applicant side, like the postal, is taking 2 to 3 months.
Mm-hmm.
So, and the mail is coming on the same day. In that problem is happening in evidence stage. That when
See,
opponent and applicant are filing 45 and 46 evidence, sorry, ma'am,
mm-hmm.
45 and 46 evidence. So
Mm-hmm.
nowadays everything is digital. Even the registry is serving only on mail. So,
Yes.
yeah, so when the opponent and applicant are servicing to each other, so if the
Mm-hmm.
mail is being received earlier, but then they are also
Mm-hmm.
for the safe side serving, by post. And
Mm-hmm.
then the applicant in some cases would say that I have received the post on this date, and by 1 or 2 dates later on, they get saved by 2 months because that 2 months duration is very strict. It is
Mm-hmm. Yes.
non-negotiable.
Yes,
So,
yes.
what would be the correct date to be considered?
The date which would be considered is the mailing date only. When you receive the mail, yes. That
Okay.
would be the,
Okay.
yes. Post doesn't matter because we all know that post to late आएगा ही आएगा, right? Anna? On the
हाँ.
same day it cannot be served. But जिस दिन आपको mail receive हो गया, that would be the date which you should consider, which the registry will also consider.
Okay.
Yes.
Okay, ma'am. Thank you.
Okay, so the Ananta is asking what is the procedure for filing a trademark at the international level? See, there's two kind of applications that can be filed. So one is the convention application, which is regarding the Madrid Protocol. So the countries which are part of the Madrid Protocol, what you can simply do, there is two options when you file the application. So there is standard application. And there is one more option, which is the convention application. You can simply go on the convention application, okay? And there you have to select the countries in which you want to file it, and then you have and the charges, and they are very different charges, unka sabka different hota hai. The countries, it varies from countries to country, and then you have to simply select the countries, and then you have to file under the Madrid Protocol convention application. You have to file when you want to file at the international level. I hope it's clear now. Okay, any other question, anyone?
Ma'am, can you explain whole wala part jo you were explaining? No, can you repeat those lines or those concept, please?
Which one, Humaira?
Ma'am, basically classification. You were explaining classification and
Of
how to
trademark
different. Yeah,
classes?
yeah,
Okay,
classes,
so
classes. Yeah.
classes. Okay, okay, okay. See, there are 1 to 45 classes. Okay, 1 to 34 are related to the goods. For example, class 5 deals in the pharmaceutical goods. Okay, class 25 deals in the clothing and headgears, footgears. Okay, all these things basically. So there are around 1 to 45 classes. You need to ask your client which business they are in. Okay. And then you have to sort it out on yourself under which class their business falls into. Okay. And in that class, you have to file their application. Is it clear?
Yeah.
So, in hypothetical situation, if users not received mail because of technical error, then what are circumstances? So dekho, whatever will be served to you by post, the date would be there. The service date always remains the same. Okay, because on the same day they have to be, sent it by the post and sent it by the mail, right? So you are going to consider that date. whichever is given on the post date. Okay. And could you mention the 3 points again for the, okay, so see, uh, under 2 sections objection can be raised. Section 9 is there, section 11 is there. For both of them, different arguments we have to give. Under section 9, you have to give inherent distinctiveness and acquired distinctiveness arguments. Okay, these are the 2 arguments. Under section 11, generalized arguments can be that applicant is the prior user. First would be this. Second would be disparity in goods and services, which is the difference between the goods and services of both the cited entity and the applicant goods. Okay. And the third would be judicial principle of entirety, which means when you are comparing the mark should be compared as a whole. Stage of evidence. Okay. So regarding stage of evidence, rule 45 is there. Okay, which you need to file within 2 months of receiving the counter statement, which is rule 45 states that the evidence which are in support of the opposition, so opponent files it. Rule 46 is filed by the applicant, evidence in support of the application. And rule 47, again one more chance is given to the opponent to file the evidences if required, if they have any more evidences. Okay, and then thereafter opposition hearings there. All these things, whatever I have told you, from filing till register, it will be before the registry only. It will be before the registry only. Registry deals with registration process. Court का कोई involvement नहीं होता till registration during this process. Any other question, anyone?
Ma'am, is it okay if I ask one more question?
Yeah,
With
Apeksha.
regards to, yeah, ma'am, with regards to the attorney registration, ma'am,
Mm-hmm.
without that attorney code, it is not possible to acquire a digital signature, right?
No, it's not possible. It's not possible. And you cannot, dekho, 2 things are required. Digital signature is required to avail the filing services, and the attorney code is required. Without these 2 things, you won't be able to file the application.
And ma'am, in case of physical filing, so in that
Mm-hmm.
case, we don't, does the applicant or the attorney just like physically signs over there, or how does it work, the physical application?
See, if you're attorney, then you need attorney code. Okay, in both the cases, in physical filing or e-filing. But if you are
Okay.
applicant and you want to file it on your own, if you want to file
Hmm.
it physical application, you just want to submit it to the registry, तो आप physically जाते हो, उसमें you do not require anything because applicant के पास attorney code कैसे आएगा, right? Applicant can
Correct.
also file their application on their own.
Hmm.
Okay.
Okay, so they can just like physically sign over there on their own.
Yes, applicant can do that.
Okay.
Okay.
Thank you, ma'am.
Okay, Apeksha. Is this registry in Chennai? See, they are at 5 places, I think. Ahmedabad, New Delhi is there, Chennai is there, Kolkata is there. One more is there, I think. I'm
Ma'am,
forgetting.
Mumbai.
Mumbai,
Ma'am,
yes, right,
Mumbai.
Mumbai. Thank you, Apeksha. Thank you. Mumbai is
Yeah.
there. Okay, the 5 places, yes. Any other? Any other question, anyone? Any other question?
Oh, ma'am, final question.
Yeah, Apeksha, yes.
Ma'am, for international, because somebody just mentioned about Madrid applications, the
Yes,
same
yes.
attorney code and digital signature can be used for Madrid applications as well, right?
Yes, Apeksha. Same would be used.
Okay. And do
Same
we
would be
have to,
used.
like, for example, ma'am, if I have an application, let's say for a UAE country, So do I have to get in touch with a attorney over there, because I would not be physically be present for, let's say, hearings or the IRDI virtual show cause hearings, etc. So do I
See,
need to hire?
yeah, I understood your question. I
Hmm,
understood your
hmm.
question. So, see, there are two ways to file the application at the international level. Okay. But this you need to clarify from the client. If they give instruction to proceed with the local associate, see what happens that you have certain countries in mind that you want to file the application in UK. Okay. So, what you are going to do, there are two ways now. You can file it through the Madrid Protocol where you can select the country UK and you can file it. Okay, and one more way is there that you directly associate with the local associate there and you can file that. Okay. What's the difference between these two ways is why we prefer hiring local associate. Why we prefer this method? Because when we file the Madrid application, the thing is you want to file in one or more countries, right? And if it will, it get stuck, the application gets stuck. Why it gets stuck? Because maybe in some other country objection has been raised, now it is going to take time. Maybe in some other country the opposition has been stuck. Okay, the someone has opposed your mark and now the application is stuck. Okay, so Madrid application kind of gets stuck. So that's the thing. But when you file individually in different countries, it is going to give you more certain advantage, right? And your application is not going to get stuck anywhere, right? Because of some other country. So this is the thing that we face in the Madrid application and the local associate. So you have to ask the client, this is the budgetary issue also which goes on. In Madrid, I think the charges are less, but when you hire a local associate basically there, so the charges would be more. So that's the thing. So simple the thing is when you want to file for three or more countries, then you should go for the Madrid only because the charges would be in budget and everything would be on place. In one single application, you are going to file in three, four more countries, right? But when you want to file singly in one of the country, what you can do is you can simply contact the local associate there and you can make the filing through them. So these
Got
are
it,
the two
ma'am.
ways. Okay, got it? Yes.
Got it.
There are
Yeah,
certain
it is cheaper.
advantages which is in
Hmm.
the Madrid application, which is with the Madrid application. Certain merit are with both the ways. So budgetary issue is there. You should go for the Madrid only. Then, okay. And if you want
Yeah.
you want to apply separately so that your application will not get stuck because of one or other country, then you should go for the local associate option.
So because if I have a good standing in my parent company, like for example, my mark is already registered in trade India, so it will be useful
Mhm.
in my Madrid application, right? Because I will have some
It
kind of
would be.
user basis. Yeah.
Yes. And you can also take it as you have to take it as a home country application is required there. When you
Okay.
file the Madrid application,
Without home country application, directly we cannot file Madrid application.
no, you need one
Okay.
registration in your home country. Yes.
Okay. Thank you, ma'am.
Okay. I hope I have answered all the questions. Okay, Janvi is asking the bar registry requirement for a trademark attorney. Is it all India bar registration? State registration will do. State registration will do, Janvi. With any bar council, you can apply for the trademark attorney code if you have any enrollment with any bar council.
I think no one has any other doubt.